My dear Shona, the floor is yours.
When I first came to Brazil in 2016, I was very apprehensive. I was afraid, I think, because if Scotland was a fish, it would be a shrimp, and Brazil is a whale. I was afraid I would be swallowed up. I was afraid that the whale wouldn't recognize the shrimp is also a kind of fish, and that what we do in Scotland is very similar, I came to understand, to what you do in Brazil, as my friend Sergio has said. But when I came particularly to Recife, I realized very quickly that not only was the law very similar, but the judges were very similar. The Labour judges were similar. They were working in a system which was short of money, which had many claims, and which required them to be dedicated, committed to delivering employment justice in very hard times. So very quickly, I thought, these are my friends, and they understand me in the way that I understand them. So when I say it is my pleasure to be back here in Brazil, that is not just me saying this because I feel obliged. No, I really sincerely mean that from my heart. I should say I didn't choose the title of this talk. The title of this talk, I could speak about this for perhaps 5 or 6 hours. So, settle down, get your sandwiches out, and we are here for a long time. No, I'm only kidding. But what I am going to say is, if I knew the answer to the second question, what are the implications of Brexit for employment law, I would be a very rich woman. Much, much richer than I am now. When it comes to Brexit, we are in the realm of speculation. Nobody is very sure what is going to happen. But I'll say a little more about that later on. If I can say, first of all, very quickly, there are 2 tribunals, Employment Tribunal Scotland, Employment Tribunals England and Wales. So when Sergio was being told there is no labour justice system anywhere else in the world like Brazil, as he says, that was a lie. We are very like you. We started out very, very small. Only one thing to decide. In the 1960s in Britain, there was a system where employers were charged by training bodies to pay for the training of their workers. And some employers thought they were charged too much. And so the government set up an industrial tribunal to adjudicate on whether the employer had been charged too much. That was it. There were very few employment rights. If you had an employment dispute, you went to the civil courts. They didn't know what they were doing. They didn't understand the employment context. People had to wait a long time to have their cases heard. The unions were unhappy. The employers were unhappy. So we in Britain in the 1960s had serious industrial unrest, partly because workers could not access justice. And what then happened was we had what we call wildcat strikes, strikes at short notice. And the government said, we can't have this anymore. We need to examine what's happening here. And so they set up a special commission, a body to examine what should be done for employment justice. And that commission, the Donovan Commission, said, firstly, give people the right to claim, to make a claim about unfair dismissal. They have lost their job unfairly. We didn't have this right in the 1960s. It came in 1971. And they said, do not allow the ordinary courts to decide these unfair dismissal cases. Give them to the Industrial Tribunal. They understand, this little body understands the employment context. And so that was the first main kind of claim that came to the Industrial Tribunal. The right not to be unfairly dismissed. The Special Commission also said the procedure of the tribunal should be informal, free from technicalities. At that time, this was a reasonable proposition. But since then, employment law in the United Kingdom, just like in Brazil, has become very complex, many, many different kinds of rights. Lawyers have become more and more involved. And with lawyers, I am a lawyer myself, so I can say this, with lawyers comes complexity. And so now, the Employment Tribunal, as we now call it, the process is formal, adversarial, like a court. Although the employment judges do their very best to make it as informal as they can, but it's not easy. Both of the tribunals in Scotland and in England and in Wales are based on dealing with the same law. Let me say a little bit more about that. We each have our own geographical jurisdiction. My tribunal deals with workers employed in Scotland or where employers have a base in Scotland. But the law we are applying in Scotland is the same as the law in England and Wales. That means we can transfer cases, and we often do. Now we can determine more than 100 different types of claim, but not claims about accidents at work. We don't deal with that. And not claims about the recognition of trade unions. That is a matter dealt with by a different tribunal called the Central Arbitration Committee. But because we can transfer cases between the tribunals, we do this often in circumstances where we have mass litigation. I think perhaps in Brazil, you now have powers, new powers, to do something that we've done for a long time. So let us say in England, there are 10,000 claims brought by women claiming equal pay with men employed in supermarkets. Let us say in Scotland, there are 3,000 claims. I can transfer my claims to England, or they can transfer their claims to me, and we will deal with all the claims together. We create a multiple litigation, and we identify test cases, sample cases, let us say from the 13,000, we identify 6 cases we are going to hear. And the decisions in those 6 cases will apply to the 13,000. This is a way we control our workload. And so I've suggested to Sergio, he can come to Scotland and see how we do this. Like labour tribunals in Brazil, employment tribunals are judicial bodies. We are independent. We are free from state interference. And we guard that independence to a very high degree. Our judges are legally qualified for at least 5 years before they can even apply to become a judge. But mostly, they have been in practice as specialist employment lawyers for at least 10 years before they can even apply to become a judge. And they must be very expert in labour law to be selected. We train them to be judges, of course, but they must know labour law. Unlike in Brazil, I think, we also have non-legal members, representatives from trade unions, representatives from employers, associations, who sit with the judge in some kinds of cases because they bring with them the knowledge of how the world of work operates. I am responsible not just for the judges, but for all these non-legal members. I have to train them, make sure they behave properly, and make sure they're well looked after. So that's part of my role. These days, however, employment judges often sit without the non-legal members, more and more. We must have members in final hearings of discrimination cases, but a few years ago, the government said, you do not need them anymore in unfair dismissal cases. And now, they sit in about half those cases. So the judge sitting on their own is more and more the norm. The trade unions aren't very happy about that, but they've learned to live with it. Generally in the UK, the trade unions are much less powerful than they used to be. There are far fewer working relationships governed by collective agreements. That's rare. And an industry-wide collective agreement is unheard of now. Over the last 30 years, the focus is on individual employment rights, not collective rights. And that is a change in the UK. Many of these rights come from European law. Most of the claims brought are brought by employees or workers, and I'll come to the difference between those two things, against their employers. We do deal with other types of case. I'll leave you to look at those when you get the slides later. They're not very common. But we have some administrative law jurisdictions. We also deal with some kinds of claims that unions can bring on behalf of their members. So a union can come to the Labour Tribunal and say, you, the employer, failed to consult us when you were selling your business. Or you, the employer, failed to consult us when you were making your plans to dismiss employees because you want to make them redundant. You no longer need them. There are obligations to consult the unions, and if they don't, they come to the tribunal. But normally, the claims are brought by individual employees or workers. There are a few other kinds of claim that can be brought, but again, they're unusual, so I won't say too much about that. So, we are talking about mostly claims brought by employees. Employees are the gold standard. Employees get all the rights it's possible to have in the UK. They get all the rights that workers get and more. There is a second category, the worker. Often European rights are given to workers. If you're self-employed, you have no rights. In the labour justice system, you do not come to us. But because different standards of rights are given to employees and workers, we have many disputes in the UK about whether somebody is an employee and gets gold standard rights, or whether they are only a worker and gets some rights, but not all the rights. And we also have disputes about whether people are workers or they are self-employed. A very good example of this that will be familiar to you, perhaps, is Uber. Are Uber drivers workers? Or were they self-employed? This is an issue that went all the way to the British Supreme Court, which said they are workers, so they have certain rights. They're not employees. They don't have all the rights, but they are workers. They're not self-employed. We can see this worked through in the law. We don't have a labour code like you, but we have many statutes that joined together are a bit like your labour code. And this statute, the Employment Rights Act, is one of the main statutes. And it says an employee is someone who has entered into a contract of employment. That sounds easy. And then it says a contract of employment is a contract of service or apprenticeship. Straightforward. Then it defines worker. So a worker is someone who works under a contract of employment. So all employees are also workers. But also, it is someone who works under any other type of contract whereby they say, I personally will do work for you, except if the contract is one which is between that of a client or customer and the person providing the service. So, maybe this morning one of you had a problem and your bathroom at home sprung a leak. You called the plumber. The plumber comes. They do the job. They did not become a worker in British employment law while they were in your home. They were self-employed. You were their customer. However, let us say that you set up next week a taxi company. And you say to the taxi drivers, you can work whenever you like. You can work for as long as you like. That would not be normal for an employee. So you've already got an unusual situation. Work when you like, for as long as you like. But when you come to work for me, driving the taxi, you must use my equipment. You must follow my code of conduct. And you must come yourself. You can't send your brother if you don't feel like working. Personal service. That is, in short, the Uber situation. They control by code of conduct, make use of the equipment that we give you. And you must, if you sign up as an Uber driver, come yourself. That is enough to make Uber drivers workers. In the UK recently, there was another case. People who played in an orchestra were told that they were self-employed. One of the violinists began to lose his hearing because of the noise in the orchestra, and they were not given any protection for their ears. The orchestra said, "You're self-employed, freelance, self-employed." So the case came to the court, to the civil court, because it was about injury. We don't deal with accident or injury. And the violin player said, "I am a worker. I get protection under European law for my health and safety." And the court decided yes. Because when he came to play in the orchestra had a lot of control. They told him where he had to sit, what he had to wear, when he had to be there. So when he played in the orchestra, he was a worker. Another large piece of legislation is the Equality Act, which makes it unlawful to discriminate on various grounds. Both employees and workers are covered. Civil servants are covered. Members of the armed forces are protected. Police officers are protected. Unlike in Brazil, in general, the labour tribunals deal with all kinds of workers and employees, even those who work for the state. So one of the cases we dealt with recently, and I think this might be of particular interest to this audience, was a claim that was brought by judges. In the United Kingdom, the government has changed the pension scheme for judges. Does this sound familiar? They changed the scheme in a way which meant that younger judges suffered the worst. They lost the most. Judges close to retirement were protected. They were allowed to stay in the best scheme. Younger judges, and you will not believe it, but I am a younger judge for this purpose, got the bad scheme. And we said, you've made this decision on grounds of age. We say that's age discrimination. And the judges won the case in the Employment Tribunal. At the second level, the Employment Appeal Tribunal. At the third level, the Court of Appeal. The government tried to appeal to the Supreme Court, and the Supreme Court said, we will not entertain you. Your arguments are so bad, we are not even going to hear them. So, in a case brought by judges, starts off in the Employment Tribunal. I think that may be different from Brazil. So now the government in the UK is forced to change the pension scheme for judges. Perhaps there is a lesson there. Like in Brazil, I think, there are many acts, statutes, governing employment law. Not a labour code, as I've said, but also in British employment law, the common law is important. Contract law, damages, the law of damages, these would be dealt with as common law outside the statute. But also importantly, we operate on a system of case precedent. So when the higher courts make decisions about an issue, we in the lower courts have to follow them. We are bound by the precedent. It is possible, though, and good judges can do this quite easily, to distinguish. We call it distinguish the higher courts. We say, that's not exactly the same circumstances. And sometimes that gives you the chance to be more flexible. On top of the domestic law, there is European law just now. In a few months' time, the system may well be completely different. But European law really falls into two main kinds. The European treaties have articles, and if it's an article about employment labour law, then the United Kingdom must follow it, even though nothing is said in the domestic legal system. It has direct effect. An example of that is equal pay for work of equal value. This comes from the European Treaty, straight in to British law. But most European rights come in the form of directives. A directive is just an instruction to a member state to do what the directive says, but to implement the directive into domestic law. Pass your own law to achieve this objective. So the European Union said, we are going to protect workers on the sale of a business. They passed the Acquired Rights Directive. The UK has to look at that and say, okay, we need to implement this in our domestic law. And so the United Kingdom passed the Transfer of Undertakings Regulations, a domestic law that implements European law. And there are many examples. So European law is firmly bedded into the United Kingdom legal system. Also, when dealing with European law, it is the top. It takes precedence over domestic law. So if we have a domestic law which doesn't properly implement European law, the tribunal must say, I am going to apply the European law. So it has supremacy. And if we are worried about whether we have understood European law properly in the tribunal, we, or any other stage in the legal system, can refer the problem, the question, to the Court of Justice of the European Union in Luxembourg. So they help us understand European law. This is how things are now. So that means that British judges, Labour judges in particular, are always looking outside the domestic system, European, what's happening in the European court. And in the same way, we look outside our system to the European Convention of Human Rights. This is not EU law. This is an international treaty signed by 47 states after the Second World War to protect human rights. And the United Kingdom signed the treaty. Indeed, the United Kingdom played a large part in writing the treaty. And what has happened is a domestic law was passed, the Human Rights Act, and it says to all courts and tribunals in the United Kingdom, so far as you possibly can, interpret domestic law in accordance with the rights in the European Convention. And these are important rights. For example, the right to freedom of thought and religion, the right to a fair trial or a fair hearing, the right to respect for your private life. So when Labour judges interpret domestic law, we take into account convention rights. So again, we are looking outside at other sources of law. This will not change following Brexit, because the European Convention is not EU law. It's separate from that. Okay, so that's where we find our law. What if the worst happens and a worker wants to bring a claim to the tribunal? Well, the first thing they need to do is phone or email the Advisory, Conciliation and Arbitration Service, ACAS. They can't come to the tribunal without doing this. ACAS is a government-funded body, but it has its own governance and independence from the government. And it's their job to try to help workers and employers resolve their dispute without coming to the tribunal. So before you bring your claim to the tribunal, you must contact ACAS. If the worker says, really, I do not want to even discuss this with my employer, I am determined, I'm bringing my claim, ACAS will say, okay, here is your certificate with your number. And you get the number, put it on your tribunal claim form, and you're in. But most people will say, yes, to ACAS, the conciliator, please contact my employer, and let's see if we can resolve this dispute. And if that happens, the time limit for bringing the claim to the tribunal stops running. You get more time, 1 month, to try to sort it out. About 12% of the claims settle at that stage, resolve in a formal agreement. Another 35% of the claims, when I say claim, that's the wrong word, because they haven't come to the tribunal. The disputes, 35% of the disputes do not proceed any further because the employee perhaps comes to understand they are out of time to bring the claim, or when the employer is contacted, they say, oh, you are quite right. We didn't pay you your overtime pay last month. We are going to put that money into your bank account tomorrow. It's solved. End of the problem. So a lot of claims through that process never come to the tribunal. ACAS is a very effective organisation. Even if it doesn't manage to resolve the claim in the early stage, they keep trying. So if the claim comes to the tribunal, ACAS continue to try to sort it out. More than half of the claims made to the tribunal are resolved without a hearing, with the help of ACAS. So this is another important way in which we manage our workload. ACAS also has a very important role in resolving collective disputes, large-scale industrial action. About 90% of the disputes between trade unions, workers, and employers are resolved by ACAS. So they are an important organisation to maintain industrial harmony in the UK. Every year they deal with nearly 1 million calls from workers asking for advice about their employment problems. And even through that telephone service, they manage to resolve many concerns. But what if that doesn't work? Well, you come to the Employment Tribunal with your claim. Amongst the common claims, unfair dismissal. Every employee, not worker, this is the gold standard, the employee. Every employee who has worked for 2 years can bring a claim of unfair dismissal. I'm not sure if that is the same in Brazil. Every kind of employee can bring a claim of unfair dismissal? No. Yeah?
Dismiss and think it was unfair.
Yeah.
Go into one of the options of the law.
Yeah.
Put in a claim.
You put in a claim. Right. Okay. Also, very common claims, discrimination. This is going to be very familiar to you. Same kind of protection as in Brazil. Don't discriminate against me on the ground of my sex, my race, my age, because I'm disabled, because I am changing my gender, from male to female or female to male, or because of my sexual orientation, because I'm gay, lesbian, whatever. Don't discriminate on the grounds of my religion or belief. All these things are covered in Brazilian law. Yeah. So when you begin to look closely, British employment law is very similar to Brazilian employment law. Possibly more similar, I am guessing, than the labour law of the United States. I think British labour law is much more like yours than American law is like your law. We have protection, like you have, against bad treatment for taking maternity leave, paternity leave, because you're pregnant. All these things you have in Brazil. We have protection when the employer doesn't pay all the wages due. When the employer treats someone very badly because they have blown the whistle. Do you know this concept in Brazil? Whistle blowing?
Yeah. But we don't actually have it like prefix in a law, but
Yeah.
it exists.
Yeah. Okay. So I blow the whistle. I say my employer is breaching health and safety law or is committing a criminal act, is acting in a corrupt way. The employer says to me, because you told people about this, you're dismissed. Or you are demoted. The law says no. Bring the claim to the employment tribunal. So, control over working time, the same as Brazil, I think. The number of hours you can work per week, controlled. National minimum wage. We have this in the UK. So I think if any of you can very quickly get a degree in law from a British university, if you were to come to the United Kingdom and become an employment judge, you would recognize many of the laws because you have them too. I am looking for 16 employment judges for Scotland. So, unfair dismissal, just by way of example, the law says an employee has the right not to be unfairly dismissed. The law says dismissal means the employer ends the contract or the employee ends the contract in circumstances where they were entitled to resign because the employer was behaving so badly. Then you come to the tribunal. But in most circumstances, you need to have worked 2 years to have this right. But if you are pregnant and this happens, or you are dismissed because you blew the whistle, like I said, or you're dismissed because you ask for your rights, your employment rights, you say, pay me the national minimum wage, and the employer says, dismissed. you don't need to work for 2 years. You are protected from the first day of your employment. Or if you were dismissed because you are active in a trade union, or because you represent the workers to protect their health and safety, and the employer says, you're dismissed, I'm fed up listening to your grievances, you're protected from day one. Okay. And that slide sets out the reasons, the only reasons the employer can try to justify their actions. I dismissed you because you couldn't do the job, because you misbehaved, conduct, because you're redundant, because if I continued to employ you, I would break the law, or for some other substantial reason that justifies this dismissal. That sounds like a very broad reason at the end, but it's very, very narrowly interpreted. If the employer cannot prove that they dismissed for one of these reasons, they've lost the case at that stage. If the employer does prove the dismissal was for that reason, one of these reasons, then the tribunal will look at whether the employer acted reasonably or unreasonably when they dismissed. So the whole concept is of reasonable behaviour by the employer. The behaviour was by the employer was unreasonable, not reasonable. The dismissal is unfair. Okay. I've already mentioned all the different types of protection from discrimination, the grounds. Workers, employees, partners in legal firms or any other kind of firm, barristers, office holders of any kind, all given protection from discrimination, and all their claims come to the employment tribunal. In the next slides, I discuss the kind of discrimination that is unlawful. I don't have time to say too much, but when you get a copy of the slides, you will be able to read in more detail. But the most important things to say are that discrimination because of a protected characteristic, direct discrimination. You are a woman, and I do this to you as a woman. Direct discrimination, unlawful. Indirect discrimination. I'm treating everybody the same as the employer. For example, I say, to use a simple example, to do this job, you need to be 6 feet tall. Far fewer women than men could meet that standard, 6 feet tall. That is indirect discrimination, and the employer must justify it. Otherwise, it's unlawful. There is a huge amount of protection for workers who are disabled, and it's very, very complex. This is a big problem in our system because about 40% of people come to the tribunal without a lawyer. And they could not, even if they are very clever, they would really struggle to understand disability discrimination law. So the judge has to work really hard to try to help people who don't have lawyers especially in disability discrimination cases. I've said already, protection for pregnant women, indirect discrimination, protection against harassment for a protected characteristic, protection from victimization. Let us say, I say to the employer, I am going to help my friend because they have been discriminated against, my fellow worker. I'm going to give evidence about this. Let us say the employer dismisses me or treats me badly for that. I am protected. Victimization. If I do anything at all to enforce my rights to equality and the employer treats me badly, I am protected. Disabled people, I think you have this too. Sergio, you'll keep me right. If an employer employs a disabled person, or someone becomes disabled while at work, the employer must take whatever steps they can to make reasonable adjustments to allow the worker to continue to work. Provide new equipment. Another example, provide a parking space so the employer can come in the car because they can no longer walk very far. Many, many claims about this, whether the employer has done enough. Lots of discrimination protection is based on European law. But we did have some discrimination protection before we joined the EU. Britain already had law which said it was unlawful to discriminate on grounds of race before we joined the European Union. We had law that said pay women and men the same for doing exactly the same job. But that was about it. Most of discrimination protection comes from European law. And one of the areas in which there has been a huge number of claims is equal pay for work of equal value. This was not something the United Kingdom had in its law. It refused to put it in its law. And so the European Commission, the lawyers in Europe, if you like, took the British government to court. Your law does not comply with European law. There is the case, Commission against the United Kingdom. While British law had made it unlawful to pay women and men doing the same job differently, what it didn't include was men and women doing different jobs which are as valuable to the employer. Work of equal value. So, in Scotland, we have about 50,000 equal pay claims. I realise in Brazil, that is a small number of claims. In Scotland, it's a huge number of claims. Most of those claims are brought against local authorities, local government. So, by way of example, you have women who work in schools. They make the school lunches. You have women, and it's mostly women, who go to people's homes and provide care to older people. Mostly women do these jobs. You have men who are gardeners, for example. You have men who are refuse collectors. The men, the gardeners, the refuse collectors are paid more than the women who are care workers, who make the school lunches. The women can come to the employment tribunal and say, my job is worth as much as his job. I don't think you have that in Brazil. Do you have that comparison? No, no. This is the biggest challenge to the United Kingdom labour court system. It has moved now from the local government and the central government into the private sector. So, for example, supermarkets. Mostly it's women who work in the shops, in the store, checking out the goods. Mostly it's men who work in the store, the supermarket warehouse, unloading the goods from the lorries stacking. The men are paid more than the women. So now, thousands and thousands of female workers in the supermarket say, my job is worth as much as his job. So this is a very common claim in the United Kingdom. And it's mostly these claims, but not only, that we group together thousands of claims and choose, with the help of the parties and their lawyers, a small number of lead or sample cases. So as I mentioned before, there may be 20,000 claims. We're only going to hear about 5 of them. The decisions we make in the 5 apply to the 20,000. I know that might not seem very familiar to you, but we have done this for many years and it works. What about Brexit? What then is the impact? I am now walking on the eggshells. This is very difficult. I sent my slides to Sergio 2 weeks ago. Yeah, about. Since then, many things have changed. Every day, things are changing. Just this morning on the BBC radio, I heard the European Commission, the European Union has agreed to extend the period we have to leave yet again. But the plan, as I understand it, is this. On exit day, when we leave, whenever that day comes, all the European law that is in our legal system, in the UK system, will remain in force on that day. And until the government, if they wish, decide to change it. All the case law from the European Court will still bind us. We must still follow it insofar as the case was decided before exit day. But any cases decided by the European Court after exit day about laws that we have from Europe now in our legal system, we don't follow them. We are not obliged to follow. The law set will say we can have regard to these cases, but we are not bound to follow. So there is not going to be a huge change on exit day. We have what will become known to judges as retained European law. But here's the worrying thing. Our previous Prime Minister, Theresa May, negotiated a deal with the European Union. And in the legally binding part of the deal, it said the UK will protect workers' rights. And it will have workers' rights to the same standard as Europe. Legally binding. The deal Boris Johnson, our new Prime Minister, has negotiated, has removed that from the legally binding bit of the agreement and moved it into the political statement, which is not legally binding. You're as clever as I am, and probably much more clever. You can probably work out what might be going on there. Rights may be under threat. The rights that might be under threat is going to depend on the political ideology of the government. But many British governments say often, Britain has a deregulated labour market. It's lightly regulated, and this is very good for business. We can see what might happen by a couple of examples from 2012 and 13. Unfair dismissal law is not from Europe, not European law, purely domestic. So the government has always been able to change it. So in 2012, they decided too many workers, too many employees had the right to claim unfair dismissal. So they said, instead of working for 1 year to have this right, now you have to work for 2 years. They could make that change without interference from Europe, because this is not European law. And then the next year, they said, we are going to limit the compensation for unfair dismissal. They could do it because it wasn't European law. These may be the sign of the things to come. At the moment, because of European law, in discrimination cases, there is no limit to compensation. People could be awarded £1 million for discrimination. The United Kingdom used to have a limit, but as a result of a case brought by a woman, Mrs. Marshall, the European Court said, get rid of that limit. because it does not give full protection for European rights. So in Britain, the limit had to be taken out of the law. Once we leave Europe, there would be nothing to stop the government bringing the limit back in, limiting compensation. Also in the United Kingdom, it would be fair to say that employers often do not like controls on working hours. They also don't like having to pay workers full pay for their holidays. By full pay, I mean, because of European law, they must pay not just basic salary, they must also pay what the employer would have earned for overtime, bonus, commission. All must be calculated so the worker gets the total pay when they're on holiday that they would have had if they'd been at work. Many British employers don't like this. So that is another area where there may be change. I can't be sure at this point in time what the full impact of Brexit will be. But certainly on exit day, the law as we have it will still exist in our domestic law. Okay, that's the most I could tell you about what might happen. Very quickly though, just one or two other matters. Unlike Brazil, workers, employees who wish to bring a claim to the employment tribunal, they have 3 months. 3 months from whatever it is they complain about. Our hearings can last many days for one case, sometimes many weeks. I think that's different from Brazil, at first instance. We have a Brazilian judge in Scotland just now, Lucio Moonhouse. Some of you may know him. He is studying in Glasgow for a doctorate. And he has been coming to the tribunal to look at how we deal with cases. And he has been very surprised at the amount of time we spend dealing with one case. But he said, and I took this as a compliment, what you do here is to deliver proper justice. The other thing finally to say perhaps is that most employment judges are also trained as mediators. So we offer judicial mediation. If the parties wish it, they can opt to have a one-day mediation to try to resolve their case. If that does not work, another judge will hear the case. But it's voluntary. It's very popular though, because when we mediate, we can help parties to reach agreements which have kinds of remedy that are outside the law. This gives you And a picture of the number of claims in Britain. So in 2018, just over 118,000 claims. Remember what I told you, ACAS has worked so that many claims never came. They were sorted. In those 118,000 claims, there were nearly 194,000 complaints, because people can come and say, I claim unfair dismissal, I claim age discrimination, I claim disability discrimination. So several claims, several complaints in the one claim. But look at the percentage of the claims about equal pay. Nearly 28,000 out of a total of 118,000, a very significant proportion. So this is a huge issue for us. I realise that for you in Brazil, you are thinking, I wish we only had 118,000 claims, because I realise you have many more claims than that. But again, you've got to think, even England and Wales, and certainly Scotland, we are two shrimps, and you are a whale. I'm happy to answer questions.